You're watching the estate planning series, Estate Planning for Singles, with Olivia Smith, co-founder of the SR Law Group.
I'll get started. My name's Olivia. I'm going to introduce Gina. Gina McKnight is a committed, self-oriented professional who has aligned both her direct patient care, personal life experiences, as well as professional business experiences into a company that serves aging adults and their loved ones through their golden years, graceful living. Through her caregiver training, advocacy, and education on senior resources, Ms. McKnight aims to empower care partners with the tools that they need to bridge the gap in healthcare services. Her client-centered approach is focused on one goal: to improve or maintain an individual's quality of life so they're able to age gracefully with both dignity and comfort. Respectively, Graceful Living's core values are to first serve with compassion, respect, and gratitude. In addition to caregiver training and advocacy, Ms. McKnight has worked in the field of advertising, marketing, business development for corporations such as Essence and Ebony magazines, Universal Health Services, and Wellstar Health Systems. She has earned a Master's of Science in Applied Gerontology from Brenau University and a Bachelor of Arts in Journalism and Mass Communications from the University of South Carolina, and has been a licensed realtor since 2006. She currently resides in East Point, where she serves as the Vice Chair Planning and Zoning Commission Board, as well as an active member of Kiwanis Club of South Cobb. In her spare time, she enjoys expressing her creativity through music and the arts, along with spending time with friends, family, and her fur baby Chewy. That is nice.
Thank you so much, Olivia. I appreciate that. I am going to introduce to you guys Miss Tisha Mitchell to you tonight. So she began her real estate career in new home sales and has expanded her business to focus on assisting home sellers. Tisha has made a high-level commitment to her real estate education, having been mentored and coached by several of the most highly acclaimed real estate coaches in the industry. She earned her Bachelor's of Science degree in Sociology from Western Michigan University, a Master of Science degree in Administration from Central Michigan University, and a Master of Science degree in Real Estate from Georgia State University. This multi-million-dollar sales agent is a certified new home sales professional and holds the military relocation professional designation. Tisha is a past member of the Douglas County Board of Tax Assessors. She is a real estate coach to top producing realtors and teaches real estate principles at Georgia State University Robinson School of Business. Tisha has a special interest in military families. She's certified as a peer mentor with the Wounded Warriors Project and volunteered as instructor with the Army Community Service Program. In her spare time, we're busy. In her spare time, she enjoys entertaining, as you can see, at home with friends, live music, line dancing, and traveling. Tisha is a former teenage mom who believes through faith and hard work, the only limit to your potential is your own limiting beliefs. Tisha.
Awesome. Thank you so much.
You're welcome.
I get the amazing pleasure of introducing the wonderful, amazing Miss Olivia Smith. She is a Georgia native and a graduate of Spelman College, where she received a Bachelor of Arts degree in Political Science. She's also a graduate of Loyola University New Orleans College of Law. Olivia has been practicing law for 14 years, starting out in criminal defense, but transitioning into estate planning, elder law, and probate as a result of a personal family experience. She is the owner and partner of SR Law Group, a boutique law firm that focuses on estate planning, elder law, and probate in the Black community. She is also the co-host of Black Parents Aging, a podcast that helps children of aging parents navigate the changing landscape. Olivia is very active and engaged in her church and community. Olivia also serves as the Probate and Estates Chair for the Georgia Association of Black Women Attorneys and on the advisory board of Changing How Individuals Prosper. Chip.
Thank you. All right. Let's
Wait, we get no applause for Olivia.
Oh, I know. What's up with that?
Here we go. We're gonna give you like real applause. How about that?
So this is estate planning for singles. And I'll kick it off. And there's a lot of similarities when you are doing your estate planning. There's a lot of similarities whether you're single or whether you're married, whether you have children or whether you don't have children. But then there are some unique differences that when you are single and you don't have a partner, you should really take note of and consider. So I made a little list. I'm gonna go through my list. If there are questions, please feel free to ask. I prefer questions, quite honestly. So when you're married, the default is your spouse, right? So who's gonna be your agent? Your spouse. Who's gonna be the executor? Your spouse. Who's gonna make these important decisions about you? Your spouse is. When you are single, you don't have that default. And when you are single and you don't have kids, you really don't have that default. Or if you're single and you have minor children, you don't have that. And so the thing that I think singles, and I'm one, and I had to do my estate planning, really have to think about is who is it that I trust? The first people that come to mind is obviously your parents. However, if life goes the way it should, your parents are going to predecease you. And so who is it that is not your parents that you really trust, that you would trust to make those really important decisions in your life, that you would trust with your healthcare decisions, that you would trust to manage your money, and that you would trust with your children? Because sometimes being single means my partner's passed away. Sometimes being single means the other parent is not interested and is not going to parent this child. And so I think it is really important to take stock of your community, your friends, your neighbors, your church members, whoever it is in your community, and figure out, okay, who are the people that I really trust? And then who are the people? So trust is always number one for me. And I say this to people that do have spouses. Trust to me is more important than skill, right? And so the first question is who I trust. The second question is, then are they capable? Because we can have really trustworthy people, but then we have to make sure that they are capable of the responsibility that we are going to give them. And so some of the things that you should consider, for instance, when you are looking at your healthcare agent, does this person, do I trust this person? Do I trust this person to honor my wishes, even if it goes against what they think should happen? Do I trust them to honor my wishes? Can they think in really high pressure situations? Will they keep a cool and calm head about them? And can they make a decision? So those are things that when you're thinking about, okay, who should be my healthcare agent? Do I have a friend that fits that description? Do I have another family member that fits that description? Who in my life would fit that description? When you're thinking about your power of attorney, truly, who is someone that I would trust with my money, with my bank accounts, with all of my finances, right? So who would I trust with my finances? Who would I trust that would always consider what I would want done, right? Who has the skill? So when we're thinking about who has the skill, we would not want someone who's filed for bankruptcy 5 times, is always asking you for money, and is not good at managing their own money. We then would not want to put that person over our money. We may love them, they may be trustworthy, but that may just not be the right position in place for that person. So when we're thinking about the estate planning documents, that's the healthcare directive, that's the power of attorney as a single person, that's what we're thinking about. Then we think about, okay, the HIPAA. Who is it that I would want to have access to my healthcare? Who is it that I would want to be able to access from either a doctor or a medical facility? Who is it that I would trust that information with? And that can be a list of people. And then a trust or a will, okay? Who is it that I would want as a trustee or an executor? Who is it that I would want handling my last business if I were to pass away? Who is it that I would trust to like make sure everything gets tied up in a bow, that would limit and minimize chaos and confusion, that could be an effective communicator both with the court and other heirs, that would respect my wishes if I, had made them. So we're thinking about all of these things when we pick these people. And then also, if you have children, you're also thinking about a guardian. Who is it that I would appoint as a guardian to care for my children if I weren't here and I couldn't care for them? Who is going to raise them in a way that would honor the way that I would want them raised? Who's going to care for them in a way that I would care for them if I were still here? Who's going to instill those values in them that I would have instilled in them? These are the things that you want to consider when you don't have that default person that, that's sitting there that is going to automatically be assumed to be the person to handle all of these roles. And these are really tough decisions. These are not easy decisions. So Tisha said, can I have someone different to care for my children than if your trustee or your power of attorney? And the answer is yes. Sometimes people want there to be a check and a balance of sort. You're caring for my children, but you're gonna have to ask somebody else for the money, right? You're not gonna care for my children and have all the money, and there's gonna need to be a check and a balance. There's gonna be someone else that has access to the money, so they can say, okay, now what are we using this for? Okay, well, and they can make sure that my kids will have some money by the time they turn 18, and it's not going to all be gone. So there are some parents that do opt for a check and balance sort of system, and there are some parents that are like, no, I trust them. If they're going to take care of my kids, I want to make sure that they have access to all the resources that they need to be able to care for them. I know that that's going to be a hardship. I want to make it as easy for them as I can. Two different perspectives. Neither one is wrong or right. It just depends on kind of where you fall with that. There was another question. Is it best to have one person or more than one? So I get real nervous when there's more than one, because that means that we're going to have to come to an agreement. And I'm guessing you mean like co-administrators or co-executors. I always opt for one over co's. There are very limited circumstances where I would say, okay, yes, let's do co, but usually my default is if we can avoid co's, then I try to avoid co's. It generally winds up causing more confusion than preventing. And when you're doing the estate planning, what we always want to remember is the goal is to simplify, right? So the goal is to simplify for whoever is going to have to manage, come behind us. It is to make it simple for them to pick up and do whatever their responsibility is. And sometimes when we have codes, it makes it more difficult. HIPAA, I had to look it up because it's been a minute. Health Insurance Portability and Accountability Act, HIPAA. Whew. Thanks, Tisha. You got me. You got me researching on the fly. What's the process for having one person in charge of my finances? So yeah, so you can have different people in charge of different things. There are different documents. So you have a healthcare directive. Generally, the healthcare directive is who is going to handle my finances and what are my healthcare wishes. Usually there's a primary and a secondary, and that's all for that particular document. Then you have a power of attorney. That speaks to your finances. You usually have a primary and a secondary agent for that. Those four people can be totally different people. It can be four totally different people. They don't have to overlap. They do not have to be the same. It just needs to be people that are fit and good in that role. What if you don't have someone that can handle your affairs? So there are trustees that are professional trustees. There are professional POAs. Usually professional trustees, they will only be a trustee. There's a minimum. So your trust has to be worth a minimum amount for them to even think that it's worth administering. And I just had they're called corporate trustees, and I just had a conversation with a corporate trustee, and I think she said their minimum may have been $250,000. So yes, there are corporate trustees. I do know some attorneys that have been trustees. I know some attorneys that have been powers of attorney to clients. We don't do that, but I do know that if there is an issue and you can't, you don't have anyone in your life that you feel like could fit that role, you can have corporate people to fit that role. So, bank accounts. I do not advise that you put people's name on the bank accounts. So, and I'll tell you why. So if I have a bank account and Miss Sheree, I said, girl, let me just go ahead and put your name on my bank accounts and let's make this easy. And then something happened to me, your name is already on that account as a owner, and we don't have to worry about it. And then you get in a car accident and it's your fault and you don't have any insurance, and then you get sued and you're at fault. And they're looking at your assets. My bank account is going to be considered one of your assets because your name is on it as an owner. Or if you get divorced and they looking at assets, my bank account with your name on it is going to be considered one of the assets. So you are then subjecting your amount, your money and your account to someone else's life and what may happen in their life. And so do not advise that. In the alternative, what we advise is you can put a pay on death, transfer on death beneficiary on the account. And that means at the time that you pass, it will pay out like a life insurance policy. Now, that doesn't help with incapacity, right? But that helps with death. That is why you need a power of attorney. So if you have a power of attorney, you should be able to access, or whoever has a power of attorney for you, they should be able to access your bank account, manage your money, pay bills, do all of those things on your behalf without their name being on your account as an owner. So those are the two ways that we advise doing that without putting your name on the account as an owner, because it opens you and your money, what maybe you save for you, whatever the case may be, to other people's liability. And we want to limit the risk, especially when we're talking about your money. Can you speak on the benefits of a revocable trust versus an irrevocable trust? And when would you recommend starting a trust versus having a will? Assets before your money. So, trust versus will. It really depends on goals. A trust avoids probate. We have people that come to us and want a trust, and they're willing to pay for trust planning, and they don't have a ton of assets, but they have oftentimes been through probate with a family member, and they're like, I do not want my family to have to go through probate. And so they may have a house, or they may have a house and maybe a rental property, and they want to make sure that their homes don't mean that their loved ones have to go through probate. So they put their homes in the trust to avoid probate. And that doesn't necessarily mean they have a lot of money, but their goal is probate avoidance. So if your goal is probate avoidance, doesn't mean you have a lot of money. It just means, how do I plan to get around my family members having to go to probate court and deal with that? An irrevocable trust. An irrevocable trust versus a revocable trust. The most common type of trust is a revocable trust. That is the type of trust that you can put things in, take things out as you wish. And you generally can operate the same as if it were in your name. The same things you could do as if that piece of property was in your name, chances are you can probably do it with a revocable trust. You put it in the trust name, and then 2 or 3 years later you decide you want to sell it, you can sell it. No big deal. You are the trustee, which is the owner of the trust. You're the beneficiary, which means you benefit from the trust, and you're the trustee, which means you administer the trust. So you're all the things while you have capacity and you're alive. So you can, with a revocable trust, you can kind of put things in and take things out as you wish. An irrevocable trust is not that way. An irrevocable trust, you put it in and it's locked. Once it's in, it's in. But it protects it. It's an asset protection trust. It also can be known as a Medicaid asset protection trust. And so because it's locked and you can't get to it once you put it in, it is not subject. So for instance, we do a lot of those because we have a lot of seniors. We do a lot of planning for seniors who are looking 5, 6, 7 years down the line and may need to qualify for Medicaid. And they may have a house that's paid off, or they may have a little chunk of money and they're like, I want this to go to the grandkids. I do not want to have to pay for a nursing home with this. I do not want this to go to the government. This is what I have. I want it to go to the grandkids. And so they're okay with not being able to touch it as long as it's gonna eventually go to the grandkids. And so for that, we can put that in an irrevocable trust. They know they can't touch it. They know it's locked. They know they can't even be the trustee. It is gone as far as they are concerned, but they know that inevitably it is going to be for the benefit of the grandkids. The grandkids are going to get it. For Medicaid, there's a 5-year look back. After 5 years, it ain't even theirs because they can't touch it. So it doesn't count as an asset for them. It's gonna go to the grandkids, and they can qualify for Medicaid. And so, though that is some of the type of planning that other folks been knowing about and been doing, that is maybe new to a lot of us that we haven't been doing. We thought that to get Medicaid, you had to be broke, and that's not the case. You just have to look broke. You don't have to actually be broke. And you can still plan and leave things for future generations, for children and grandchildren. You just can't touch it or have access to it. And so that is a lot of the planning that we do with irrevocable trust. But the difference with irrevocable is you can't touch it. Once you put it in that trust, it's locked. And it's gonna go and do whatever it is you have intended for it to do, but you can't say 2 or 3 years from now, I'm in a pinch, I need that money that I put, it's gone. Like, don't think about it, it's gone. And so that's the difference between the two. Let's see. Yes, you do need an attorney to put that together. Life insurance. There is a specific, and I'll just be honest with you, there is a specific life insurance trust. I don't know a whole lot about that specific type of trust, because what we usually wind up doing with life insurance when we do trust planning is we make the trust the beneficiary of the trust and not the owner of the trust. There is some planning where it would make sense for the trust to be the owner of the life insurance policy. I haven't done that type of planning. The planning that I've done, it is sufficient for the trust to be the beneficiary. And so what happens is when you pass away, that life insurance policy flows into the trust. And then whatever the instructions of the trust is, whoever gets what or how that's supposed to go, that is how that money gets distributed. Okay. I think those are all my questions for now. So
let's move into the real estate portion then. So some things that you need to think about with regard to estate planning, with regard to ownership of real estate, is you really kind of want to determine how you hold the title to the property. It could be solely in your name or jointly with someone else. You need to understand the implications of the different ownership structures. And we can have Olivia loop back to talk about what those ownership structures are. But it's important. Most people, when they get their deed, when they purchase a house, pay no attention to how ownership, how their property is owned. And it makes a huge difference as to how it gets transferred after death. The other thing you need to consider is a beneficiary. So consider designating a beneficiary for your property. That can help streamline the transfer of ownership and avoid the pitfalls. Now, what I'm going to say to you is, I'm not the expert on how that should transfer. I am simply saying these are the things that you need to consider when you own real property. Okay. The other thing you need to take into account is any outstanding mortgage or debts related to your property. So a mortgage that you owe on that property, you can't just transfer it without there being a plan in place for how that mortgage is going to get paid. And sometimes when you're going through the probate process, it takes time. So there should be some provisions in place as to who and how that mortgage is going to be paid while this estate planning process is worked through. So you want to make sure that whomever you're working with understands, 1, who your mortgage is with, 2, how it's paid, and 3, what is the balance owed on it, okay? And you need to have a provision to share that information upon your incapacity your incapacity or death. The other thing is property management. If you own rental properties, think about who will manage those properties in your absence, either in death or in incapacity. So many people have a real estate portfolio and they get in a car accident or for whatever reason, they become incapacitated. And a lot of what's happening in their property management happens in their head because they're doing it themselves. Well, in the state of Georgia, and I'm not sure about other states, is that it is illegal for you to manage another person's property without a real estate license. Even if it's your cousin, your brother, your sister, if you own those properties and that person does not have any ownership interest, that kind of could be breaking the law without specific instructions from your estate to allow them to do that. So you might want to designate who's going to manage those properties for you and include instructions on how to handle the rental income and maintenance. So if something happens to you and you're incapacitated and something happens at that property, who's going to be responsible for making sure that that tenant is still getting the service that they need when you're not available? The other thing you want to think about is the tax implications, right? So you need to understand the potential tax consequences associated with your real estate holdings. So you want to, if you have multiple rental properties, if you have additional properties, you want to have a conversation with your tax professional and explore ways for minimizing your tax liabilities. You may decide that I am going to trade up my properties and continue to do a 1031 exchange, thus avoiding taxes. But in the event of your incapacity or death, that plan might go out the window, okay? We've already talked about establishing a trust for your real estate assets, or for you, period. But there's also trust that you can establish for your real estate holdings. So you can kind of put that in place with your overall financial plan, but you want to make sure that those deeds, most deeds are public record. And so like Miss Olivia said, if something happens and you get into a car accident or something happens, people can just look you up and see what properties you own, and all of that becomes a part of a potential lawsuit. Whereas if you have those titles in a trust, then, you know, sometimes, well, they can't find them, so they don't know you own them. Finally, you want to think about your future plans. Like, what are your long-term goals for your real estate? So if you have, like Olivia said, if you have specific intentions for your properties, such as passing them down to family members or even donating them to a charitable organization, you need to make sure that you include whatever that is in your estate planning. If you live close to a university and you want to donate that property to a university for future growth, it has to go from your head into a written plan. There's many, many things that you can do with real estate and passing it along and all of that, but make sure of the 7 things that I've named that you have a consideration for your real estate, not just for your investment property, but also for your primary residence. It's not as simple as I'm just going to leave it to my sister. There are other things that you can do with real estate. Do we have any questions? Okay, you had a question. If I'm the only one on my deed, will the person as the trustee handle things? The answer is yes. If it's in your estate plan, you just need to spell it out. So your trustee can handle the real estate as well as the other things that we talked about. One person can handle all that. But what you want to make sure is that your trustee has a relationship with someone who understands real estate and understands the market, because you know, we can get into a market where, you know, it's sell, and they're selling in a fire sale because there's not a provision for the mortgage, there's not a provision for maintenance, and they just want to get rid of the property. And you're losing, you know, a significant amount of money in your estate because of how it was sold, and it was sold quickly. So you want to make sure that there is some plan in place to be able to give you a buffer. Real estate is a very slow asset. meaning you can go to the bank and get your cash out tomorrow. Real estate is going to take some time, especially if there's not a plan in place. So when you think about it, you have to have someone who has the ability to be able to sign, because in your incapacity, let's just say I'm your sister and you own a property, and I've decided I'm your only heir and I want to sell it. Without there being a written plan in place, I cannot transfer that title, because your ownership survives death. And the person that is authorizing to sell that property has to have the legal authority to do so. Otherwise, it gets very hairy and very complicated, and all the while the property may be sitting there deteriorating, the market is changing, the property could be even going into foreclosure because there was not a plan in place to pay that mortgage in your incapacity or death. All right, let's see if we got another question. In Georgia, how do you insure how do you insure a house with a mortgage, not paid house, is not on a property deed, goes to a designated person that cannot be contested, taken away, and after death deed can be put in their name? So, Michelle, do you mind popping on, unmuting yourself, and clarifying your question? Are you okay with that?
If you have a mortgage, the house is not paid off, but you want it to go to a designated person after I die, that you don't want that property to be contested in a will or taken away after I die, how do you make sure that that deed goes to that specific person and put in their name?
Is that with a mortgage or without a mortgage?
With the mortgage still being on the house.
Okay. You want to hop in on that one, Ms. Olivia? You want me to handle it? No,
So you asked about putting the name on the deed. You can absolutely add someone to the deed with right of survivorship. However, there are benefits that you receive from inheriting property that you do not receive from adding someone to the deed.
Is that the same for a family member and non-family members?
I believe so. I've heard no different. So for instance, if I inherit property, let's see, the easiest way for me to try to describe this. There is a piece of property. It was bought 1950-60 for $50,000. It is now worth $100,000. If the name was just put on the deed as right of survivorship and the owner passed and I want to sell, there are some capital gains taxes that I'm gonna be looking at, about $50,000 from when the purchase price to the sale price, right? What that difference is. That's if the name is just on the deed. Same set of facts, and instead of the name being on the deed, I inherited the property. There is a step up in basis that you get from inheriting property. So instead of looking at the value of the property when it was bought 50 years ago, we look at the value of the property when the person passed. So if the person passed and the property was worth $100,000, and now I'm trying to sell it and it's worth $100,000, there's zero that I would pay in capital gains tax. Now, I'm not a tax person, but I can tell you that much. There is just some IRS and some tax benefits that you get from inheriting property versus just quit claiming it, which our folks are real good at, quit claiming it back and forth to each other, that you get on that end, that you're not going to get that benefit. And I mean, and the benefit is when you go to sell. So if you're like, I'm never going to sell it, then okay, like that may not be something that you even have to think about. But if you ever need to or want to, then that's going to be something that comes into play. And I don't know, but the mortgage, understand, and Tisha can speak more to this. The deed is the ownership. The mortgage is something separate. It's the note on it. And so just because you own it doesn't mean that mortgage company is going to just transfer that mortgage to you. What happens a lot of times in probate court is you inherited the property, right? So we're happy to put that in your name, the deed in your name, but there is still $100,000 mortgage, and the mortgage company wants to make sure that you're going to be a credit-worthy owner, and they're not just willing to transfer the mortgage to your name. They want you to qualify. And so, or they want you to refinance so that you can qualify, because they don't know you. And they don't know if they're going to get their money from you. And so they're not willing to just, assume that they will and leave everything status quo. So that is what oftentimes clients, and it affects people that are poor, where the house is usually the biggest asset, right? And they got this asset, there's equity in this house, and they've got this mortgage that nobody can qualify for. And so then what do we do? What do we do, Tisha? We got this asset. We can, as the attorney, I'm happy to transfer. We've settled everything as far as the estate. I'm happy to transfer the deed, but we've got this mortgage, and we know the person that is now going to be the owner can't qualify for the mortgage. What do we do?
So whenever so to piggyback on what Miss Olivia said is, again, when you purchase the house, you qualified for that mortgage. So there's two things here. So there is the ownership deed, right? And then there is the warranty deed. One is who has actual ownership of the property. The other is who has financial responsibility for the mortgage. And those are two different things, okay? Two different things. And generally, when the ownership changes, then what happens with the mortgage is, when you get a mortgage, there's generally a clause in there that says due on sale clause, okay? So whenever there's a title transfer, the mortgage company can call that note due. And what that means is, if you own a property is worth $200,000 and you've paid, let's say, half of it, and you owe $100,000 on it, and you passed or you're incapacitated or you deed that property to someone else, then the mortgage company says, we want our $100,000 tomorrow because the ownership changed. That is the activation of the due on sale clause. Now, some mortgage companies, they don't care as long as they get their money, but they reserve the right at any given moment to call that note due. And so if the person that you're changing the ownership interest to piggyback on what Miss Olivia says, does not qualify to make that payment, that mortgage company can foreclose on the property and call all $100,000 of that due. And the person that you left the house to doesn't have the money. So they're going to foreclose, and for the most part, all of your equity is lost at that moment. And that happens a lot with reverse mortgages with older people where, they're older, they don't have a lot of cash. The reverse mortgage company says you can stay in the house until you pass. And the heirs come and say, we about to get this property because, mama had that property and she owned it free and clear, except for she did a reverse mortgage, which says that we're going to come get that property upon her passing. Okay. So keep in mind, when you make these decisions, if you don't, that trust is a level of protection that ownership changes without alerting the mortgage company. And that can happen in a trust. But when you change that deed, you take the chance, there's a possibility that the mortgage company is going to call that note due. Any questions about that? So the whole point in having an estate plan and having the trust in place is to keep people out of your business so that ownership transfer can happen quietly. So, yeah, that's it for me. Miss Gina, you ready to hop in and talk about caregiving?
Yes, absolutely. Ladies, each one of you have touched on some very important aspects, especially when it comes to the caregiving side, and particularly the financial planning portion. What tends to happen, as caregivers, we want to care for everyone else and not so much of ourselves. When we see something that is needed to be done, we just go ahead and do it, right? So if that requires digging into our pockets to take care of, a copay at the healthcare facility, some supplies and things that mom and dad need, some medication that you're actually picking up. The reason why I'm bringing up these items is because it still costs money. And if you have to think about your own financial plan so that you don't fall behind in of your own goals in your own life. So financial planning for yourself is golden. So you can stay on course, have a budget, and also, plan for your own retirement. So I hear this quite a bit. It actually has come up for me, considering that I'm single over the years. There's an assumption that because you are single, you don't have expenses. Like you don't have, I'm not married, I don't have kids, so, she got it. When the reality is that people don't consider is that I'm single, but all of the bills is my responsibility. So I don't have help. So when you think about your financial plan, create your own budget, stick to it, and don't fall into the trap of I know these things are needed. I need to come out of my pocket. Figure out a way to work with your family, other family members who can assist you in whatever caregiving role that you have. The other thing I have on here in terms of the legal documentation, Olivia has already, and Tisha actually has touched base on those items with the POA, healthcare directive. It's important because we do forget about ourselves. When we think of estate planning, we often think of what's going to happen if I die. But as a single person, you also have to think of what's going to happen while I'm here. So you might become in a position where you are disabled, or just can't do some things for yourself, can't just go to the store and get groceries, or taking care of some medications for your own self, or supplies that you actually need, and you will actually need someone else to do those things for you. Have those legal documentations in place so that they can. The healthcare system so much these days have gone electronic. HIPAA is important and they do stick to it. So if someone does not have that documentation to say, yes, Gina McKnight has authorized me to handle XYZ transaction or speak to this healthcare professional, they're not going to share your information. So get those items in place. Now, I bring this up all the time because I've been here, and I'm so glad that I'm past it now. But self-care is important. We tend to fall into a routine and a role, or that roller coaster of, I got to do all of this and then I'm going to take care of me. Let me finish doing XYZ for mom and then I'm going to take care of myself. Well, along with that financial budget and plan that you're going to put in place, you're also going to think about your self-care. Because at the end of the day, an hour or 2 hours out of the day for you, even if it's 20 minutes for you, your self-care is important for not only your physical, but also your mental health. And then also prioritizing your own health. I mean, like I said, sometimes we think of ourselves last. You forget about your own doctor's appointments. The checkups that you actually have to have. That's a part of, I mean, it's not a state. The state is your physical body, but you have to check in on yourself to make sure you're okay so you can continue to check and take care of everyone else within your circle. And lastly, I don't want anyone to ever forget about this. Sometimes it's harder for some people than others, but really building a support team. I raised a question for Olivia about, okay, so what if I don't have anyone that I trust to put my, to give them all access to everything that I have? There are some people who have lived their life sort of like in solitude. They don't have a network. Build the support now. It can be your neighbor. Granted, it might be limited information that you want to share, but still there's people around you that you may not even be thinking about that will help you. And from caring for a loved one, but also when it comes to taking care of you. There's people, I'm sure, within your circle, family, friends, colleagues, sometimes I call it family, doesn't always have to be blood, right? Who is able to actually make sound decisions on your behalf, who actually do care about you. There's people who may be picking up the phone, calling you now, asking, who just check on you to see that might be the person that you might want to consider. There's things that you can actually do in place. I don't want to necessarily say testing the person out, but there's things, different scenarios through conversations that you can have within your circle to see if that is even something that they're willing or able to do. But at this stage of our lives, and I'm saying in the mid 40-ish on up range, I mean, really take some time to really consider and think about your network. And then lastly, the final point is your home. There is a time when there's a lot of real estate that's out there where the focus is on 3-level living, 2-level living, not a lot of 1-level singular. So if that is the case, think about if I were ever to, be in a position where I can't go up these stairs, what would be my other option? What would be the alternative? Could I make this living room into that place? Just think about your living environment, and could it actually be something that is that can take you on over the years? And if not, consider a property that can. That is 1 level, that it wouldn't be so complicated if there was ever an injury for yourself. And those are just some little tips that I have. Of course, there's a whole lot more when it comes to caregiving, but those are the key highlights.
Thank you, Miss Gina.
Yeah.
I just want to make sure that I got all the questions in the chat.
Okay.
So I believe we answered. If not, please let me know. And Ms. Paula asked, is there an option to do a joint tenancy or transfer on death deed so my primary home will transfer to my children without probate? So Ms. Olivia, you answered that question, and you talked about, yes, that can happen, but we talked about the implications if it does. And if we haven't answered your question, Ms. Paula, just please put it in the chat if you need more clarification, or chime in. Ms. Cunningham asked the question, do you need a will for each state that you own property in, assets or funds, or in the estate plan, one estate plan can cover it all?
So, yeah, no and yes. So if I haven't done my estate planning in Georgia and I moved to another state, technically that state, our country has something that is called full faith and credit, which means states give full faith and credit to other states' laws, documents, legal documents, and those things. So if I do a will here in Georgia and I go to Florida and die, they will probate my will from Georgia. That happens all the time. That can happen. So it is not necessarily a situation where you have to get new estate planning documents just because you move. Do I think that it is a good practice for you too, if that is a place that you plan on remaining, that you make sure that your documents come into alignment with that state's laws? Yes, because you're going to be interacting with that state's doctors and banks, and you don't want to have a fight every time you need to have something done. And that has been something that, you know, I've experienced with clients who call and they're like, I'm at the bank, they won't. And so as a good practice, and probably less of a headache to you, if you move to a state and you plan on remaining there, the best practice would be to update your estate planning to reflect the laws of that particular state. But if you go there, you don't do it, and something happens, at least for your death documents, they will still honor them. Now, for your healthcare directive and your power of attorney for Georgia has Georgia specific documents for those. And so the ones for other states may be totally different. I don't know. So those two, I would say get those redone if at all possible. But if you have a will, certainly it will still be upheld. If you have a trust, you should be fine. But if you're going to remain there for any long period of time, or if you're going to remain there indefinitely, I think the best practice would be to get those updated with that state that follow that state's laws.
Okay. Thank you so much. Looks like we have got all of the questions taken care of in the chat. Please, if you would like, take a screenshot of our contact information. We will definitely send you more. This is a series for us. We've done almost a year now going through different topics on the estate planning, caregiving, and real estate kind of trifecta. We appreciate you for coming in and taking a listen to what we had to say. And if you don't have any additional questions, we are going to call it a night in just an hour. Thank you so much for coming.
Thank you.